Hello, I'm Scott Brown with Scott Brown and Associates. I'm board certified in family law here in Texas, and today we're going to answer questions about child support. So how is child support determined? The parent with physical custody of the children will usually receive the child support. State child support guidelines provide a formula for calculating child support that considers the children's needs and the parent's ability to pay. Most parents pay the guideline amount, but parents can also agree on a different amount. The court will not allow support below the guideline if it is insufficient for the children's needs or unfair to the receiving parent. The court may order support that deviates from the guideline as well. For example, the court could require support above the guideline when a child has special needs. The court could order support below the guideline when the child has other sources of income. Also, the courts can deviate from the child support guidelines if, for example, you have a high wage earner and the children are accustomed to, for example, private tutoring lessons, baseball lessons, ballet, dance, any of those kind of things that the private school tuition, any of those kind of things that the child is accustomed to. If you have a high wage earner, the court can also exceed the child support guidelines. How long does the obligation to pay child support last? The obligation to pay child support lasts until the child reaches the age of majority. Most states define the age of majority as 18. However, a few states define it as 19, 20, or 21. Here in Texas, for example, normally in a divorce decree or a child support order, the parent paying the child support has to pay child support until the child turns 18 or graduates high school, whichever is later. And child support can also be continued beyond majority if the child has special needs. A parent's obligation to pay support could end before the child reaches majority when a child is married, is emancipated, joins the military, or leaves home and becomes self-supporting. In most states, a parent must petition the court for an order terminating the child support obligation even when the child has aged out. Can the initial child support amount later be increased or decreased? A child support order can be changed when it is no longer appropriate. Now, parents can agree to a change subject to court approval. The court will usually approve an agreement increasing support, and a court will also be cautious about approving a reduction and will want an explanation as to why the reduction is necessary. If the parents cannot agree, the parents seeking the change will need to request a court hearing. Usually the standard that the court uses is, has there been a material change of circumstances? Another standard that the court looks at is whether or not the child support amount would differ by either 20% or $100 against what the original child support order is. The court can change the amount temporarily or permanently. Can a parent withhold visitation if the other parent is behind on child support? The answer is no. Child support and visitation are separate issues. Although courts will consider the best interest of the child when deciding both issues, non-payment of child support is virtually never a reason to deny a parent visitation. A parent who refuses to allow the other parent to exercise court-ordered visitation can be punished for contempt of court, which could include the payment of attorney's fees as well as possible jail time. Is an unemployed or disabled parent excused from paying child support? No. Loss of income does not stop child support from accruing. The unemployed or disabled parent may ask the other parent to agree to a temporary or permanent reduction in child support or may petition the court for a reduction. The unemployed or disabled parent will still be required to pay child support if the parent has income. Unemployment benefits and disability benefits are considered income available for child support under most child support guidelines. What penalties can be imposed on a parent who does not pay child support? A parent who does not comply with a court order to pay child support can be held in contempt of court. The judge can fine the parent and even send the parent to jail. The judge can order that the child support be deducted from the parent's wages. The parent's property can be seized, his or her tax refund intercepted, and his or her driver's license and professional license is suspended. In some cases, the parent can even be prosecuted for a crime. Please call my office to schedule a consultation if you would like to discuss a child support or other family law matter.